The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. This court from recess, now sitting. You may be seated.
Case number 11041, speak to the clock.
May it please the court. My name is Shannon Crane, and I'm the attorney for the appellant, Chris Boggs, Charles Boggs. And I would like to reserve 3 minutes for rebuttal. And pursuant to your earlier request, I'm going to give a little bit of factual background so that the audience will know what happened in this case. It was a 3-week trial, so I can't go into all of it, but suffice it to say, this was a murder case in which a young woman was killed in her home. Her son was in the home with her. He was 5 years old. Someone came into the home and shot her 3 times, and the son found her. Went to the neighbor's home, was able to get help, but by that time she was deceased. The state presented evidence at this trial that it was a mistaken identity, that their theory of the case was that this was a drug deal, that they were going to rob a drug dealer who was similar to the victim, and they went to the wrong house, and then they shot the wrong person. And that testimony was brought on by many witnesses from the community that testified to this alleged conspiracy to go rob this other individual over money or drugs or both. There was a lot of inconsistent testimony going back and forth about what the plan was, who was in on the plan, and what happened. But it appeared that one individual was the kingpin, and his name was Billy Craig. And he was a co-defendant. He was also charged in this case with the murder of Jennifer Huffman. And I know this is a very sad case because this woman was killed and her son was there, but we need to look at the facts of the law, not necessarily the facts of the case. And in this case, Billy Craig was central to this case and the state's theory. And it was his associates that were surrounding this case that testified in this case. And they testified that Billy Craig told them certain things. And Billy Craig, as I said, was a co-defendant. When his name was mentioned and what he said, defense counsel would object to hearsay. And each time defense counsel objected to hearsay, the state argued that Billy Craig was under subpoena and was going to testify.
When was Craig's counsel notified that the state intended on calling him in their case in chief against your client? Was this during the trial, before the trial? When, in proximity to the trial, did the state have the expectation that Craig was going to testify?
I believe the testimony at the sentencing hearing, and also there was another hearing that I supplied the transcript for in this case, and it was Billy Craig's case. It came out that there was really no conversation talking to Billy Craig's attorneys about his testimony until the trial had already commenced.
Until trial had commenced?
Yes, I believe Greg Bell was the attorney for Billy Craig, and I believe he testified that he ran into Tom Stanton, one of the prosecutors, on the courthouse steps during the trial, and Mr. Stanton said to him, you know, we're going to call Billy Craig. And that's when Mr. Bell said, well, I don't think he's going to testify.
And did that occur during, prior to, or after the assertions were made to the trial court that Mr. Craig was going to testify?
Some of them were before, and some were after.
Okay, thank you.
There were several.
Before you get started,
Sorry.
let me ask about Billy Craig. Had he been given a plea deal?
There had been a plea offer in exchange for his testimony, and then Mr. Stanton had sent a letter saying that they were not going to follow that plea offer because they don't believe that Mr. Craig had followed it, so it was revoked. And that letter went out in September. His trial did not start until October. So the state, in my opinion, knew that he did not have an obligation to testify under a plea agreement.
Why didn't the defense know that?
The defense,
If there wasn't any plea agreement, he had not pled, defense counsel should have been aware that it's very likely that he'll take the fifth, and that would be the defense attorney's advice.
I don't believe that the defense counsel knew that, because they were different counsel. There was a different attorney for Mr. Watson and Mr. Craig, and I don't believe they were talking. And I think the testimony in Mr. Craig's hearing later to enforce the plea agreement, that was brought out.
Let me get that date again. The plea offer was revoked before Billy Craig, before Locksmith's trial.
Yes, and I believe that's part of the record. I could find that for you, but there's a letter from Thomas Stanton to Mr. Bell stating that that plea agreement had been revoked. There were several comments that Billy Craig, hearsay comments from Billy Craig, that I believe were very detrimental to the defense. Remembering the way that this case had, there was no physical evidence connecting anyone to this murder whatsoever. They didn't have a gun, they didn't have any DNA, there was just no physical evidence whatsoever. The only thing connecting all the dots in here was all this testimony from various people in the community that went around what Billy Craig was doing. And he testified, and I believe this is the most damaging part, there was hearsay testimony that he told someone that the defendant is the person who shot her. He was identified as the driver. Billy Craig was the driver of the car that went to that house, and he is the one who then identified to another individual after the murder that Chris Loxam was the shooter. That was objected to as hearsay, and the state said he's going to testify, and so they'll be cross-examined Mr. Craig, and then he didn't testify.
And which witness is that? Counsel?
That was Crothers. David Crothers.
And was David Crothers on the list of the limiting instructions?
Yes.
And so why doesn't that limiting instruction eliminate any issue we had as to Mr. Crothers' testimony?
There's several reasons, one of which I don't believe it included all of the hearsay testimony that was in this case.
No, but I'm talking about Mr. Crothers. The jury was told to disregard what Mr. Crothers said Mr. Craig did so.
How do you put that cat back in the
How do we not believe that the jury follows the instructions? Isn't that just the basic presumption that we apply?
Well, if we could apply that presumption, then you would never have to worry about whether they did or not. But we do worry about whether there is a question as to whether a limiting instruction was sufficient. And in this case, I don't believe a limiting instruction can be because of the significance of the statement. If it was that he looked like the shooter, or he may have been in the area or something, but to actually identify him as the shooter, I think is so critical to the state's position that a limiting instruction cannot make that go away. I think that's the difference why that limiting instruction was not enough. In addition, I think the limiting instruction didn't identify all of the hearsay statements that should have been included.
I think the record reflects that's correct, that the limiting instruction didn't identify all of the different witnesses as hearsay came in through. But didn't the defense have a role in drafting that instruction?
Well, defense did. Yes, they did. And
So it's not invited error?
it was not invited error because the defense did object to it. And the conversation at the time was, well, this is really hard to do, to find all of these that happened in this three-week trial, but we're going to do our best. And that was the statement from the prosecutor and the kind of attitude that the court had. Well, we're going to do our best, we're going to try to find it, and then this is my instruction, and they're going to follow it. But when they said, you're going to disregard these three people, then that gave them permission to look at those things.
As to the statement of Mr. Carruthers, and actually any of those others of the circle
of friends that were, well, actually, to see anything that Mr. Craig said. Why does the co-conspirators exception not apply?
Mostly because they did not happen before or during the conspiracy. These are statements that were made after the conspiracy. And my understanding is that co-conspirators, the case law is clear that it has to be during the pendency of the conspiracy, relating to the conspiracy, or in the attempt to cover it up or, to hide it.
And
that's
you
not
would
what
say
happened.
there was no attempt to hide this or cover it up?
I don't believe that Billy Craig telling Crothers that he's the one who shot it is in any way trying to cover this up, or this was just someone confessing or saying what happened afterwards.
And as to your issue about the confrontation clause, how are any of those statements testimonial?
Well, I believe the two that were made to the detectives were testimonial. And those two were from Detective Harpo and also Detective Rodriguez, who also then repeated what Crothers had said. He repeated that Crothers told me that Smello, which is Chris Watson, is the one who shot her. So we have the statements to Detective Harpo are definitely interrogatory. They were interrogating.
But they're coming from Crothers, right?
Well, those are two different instances.
Well, I think it's ridiculous that you have to separate them out.
Yes.
Because the person, if Clarence is correct, and he wasn't speaking to law enforcement.
That's correct. The
So
one
it's not really testimonial.
yeah, the one to Crothers I don't believe was testimonial.
Okay.
I think
It only
that
comes
was
directly from Craig to law enforcement.
correct. I believe the one to Crothers was hearsay, and it was not co-conspirator. I don't believe it falls under that exception, and it certainly didn't fall under the exception that was used at trial because he did not testify. The state brings out the fact that they tried their best to get him to testify, but that really only comes into play as if you're trying to use prior testimony, and the clearance is unavailable, and that's not what we have here. I will say that the state did try to get him. They did everything they legally could to get him there to testify, and he refused. But I don't think that's relevant to this case at all. I don't think it fits into any of the exceptions.
I was going to cut the way off.
Oh, okay. Well, then I do want to ask a question, okay, because I'd like you to address harmlessness. Because I'm not sure that in light of your client's statement to, was it Miss Branton, that he had stayed up 8 days too many and that he shot her. And then in light of her testimony that she was part of a conspiracy that included the defendant to commit the robbery, how any of this makes a difference? Can't we just say, given his admission and her testimony, that any of this other hearsay is just add-on?
Can we add on a factor? Would you accept the friendly?
Sure,
Just
certainly.
And the video of him in the room imitating what happened.
Imitating what happened.
Reenacting the murder. It seems
Yes.
like those three facts were pretty damning.
Okay, so the three you're talking about is the statement that Ms. Branton, the video from the jail, and what was the third one?
Her testimony about there being a conspiracy.
Okay. Under harmless error, you have to look to see the whole circumstances. And in this case, we have very frail evidence. Those three things are contradicted all throughout the testimony. The testimony is just everywhere in this case. And there is reason to question each and one of those witnesses about their credibility and their history. Kylie Branton, I believe, she's the one who has 18 aliases in Casper. I mean, there's a lot of reason to believe that if you didn't have what Billy Craig said, pointing in the finger, that you could have gone after these other people a lot more effectively and said, you can't believe these people, they're liars. But it's really hard.
There was nothing about the fact that Mr. Craig's testimony and that would prevent the counsel from making that attack. That attack would be made anyway, right?
It could. But you have to look at the totality of the circumstances. And when you look at all of them, Billy Craig's statements are very important. The statements he makes just to get the ball rolling to police that he knew that she was shot in the head. That was hearsay. That was ruled by the court be hearsay and that's admissible under, he was going to testify, so. And all of this connects all the dots. And so if you take his big statement out there, then the whole thing just falls apart. So yeah, you have 3 or 4 things that are damning, but you also have a lot of other things that are not. And you have Mr. Watson throughout all of this saying, this is just what Billy Craig told me, and I am innocent, I didn't do it. So Billy Craig saying, no, he's the one who shot him, I believe is very, very relevant to this case.
What about the reenactment of the murder portrayed by your client?
Well, that was actually done, I believe, after all the evidence had come out about how it had happened. And he was saying, this is what they said happened. He claims he was not reenacting it from his own memory, but from what the newspapers and the press had said. So I think there's a discrepancy. It makes it look like, and the state wants you to believe that that's what it looked like, but there's 2 ways of looking at that. And I believe the jury could have looked at it as he wasn't reenacting that. He was just saying what he believed happened. And that's in the transcript. That's in the record.
Put that in a timeline for us, if you could. Sorry, are you saying that was after the preliminary hearing and evidence had come out?
I don't remember when he was in the Fort County Jail. That might have been before.
And because I thought none of this had been reported in the press.
The preliminary hearing,
Until the preliminary hearing.
there was stuff in the paper before that.
That kind of detail then?
I believe so. And he was also stating that Craig is the one who told him all of this. So he was denying that he was reenacting it from his own knowledge, but from what Billy Craig had told him. And I believe the jury couldn't believe that, especially when you look at the totality of all of these witnesses. If you were sitting at 1,700 pages of transcript, and when you go from one witness to the other, and they just go back and forth about what was really happening and who was doing what and why, I think that there's a lot of credibility issues. And so I think that Billy Craig saying that, and Billy Craig bringing it all together, with all the dots together, I think had a big impact in this case. And that's why I think it's not harmless error.
Any further questions? Thank you, counsel.
The police court. My name is Keith Schroeder, I'm the Carroll County District Attorney. I guess what I want to start with is just kind of picking up on that theme. Billy Craig wasn't the only evidence in this case. This trial took 3 weeks. I was trial counsel, Mr. Maxwell was trial counsel. We presented over 100 witnesses, more than 200 exhibits. There were a lot of other witnesses. Now, the state will concede that this was a case that wasn't full of a bunch of saints. There were a bunch of persons who acknowledged having committed robberies before. We had a lot of those problems, but we did have other evidence. First of all, we had...
How many of those other witnesses got their information from Billy Craig?
None of, well, 9. I'm not sure exactly how many got it from Billy Craig.
But just because you have other witnesses doesn't negate the fact that Billy Craig's hearsay testimony is coming in.
Well, we don't believe, first of all, we believe it was corrected with an admonition. We believe that admonition, and we turned to State versus Sappington, which is a 2007 case that this court tried, and I just want to remind you about that. That was a case in which the defendant had actually 2 murder cases pending at the same time. And as there's a motion in limine to keep out evidence to the second jury about the first murder case. Or I'm sorry, I guess it's the other way around. Not let the first jury know about the second murder case. And during the trial, the state accidentally placed the murder confession in the second murder. In the first murder trial. There was an admonition given. At that point, this court held that the defendant was not substantially prejudiced based on an admonition to disregard that because there's a belief that juries are presumed to follow the instructions that, in fact, the judge gives them.
That's definitely the law. We presume them to follow their instructions. But this instruction was not perfect, was it? It wasn't complete.
There were several witnesses that were left off. And I list all 5 of them. I think, First of all, the defense counsel worked in preparing this admonition, went through the transcripts and finally said, these are the three witnesses and we agree with that. Then what happens is, as they're going through the instruction and how the wording should be changed in the verbiage, finally they get to the point where the judge says, Mr. Brown, do you have any objections to this instruction? And after having helped draft it and talk about what should be in it, he says, well, I guess his quote was, to be consistent, I'll object. Which we question whether or not we acquiesced in it, but in any event, that's how it happened.
Can you help me understand why that instruction, after listing the witnesses they should not consider, it had a statement that said any other evidence about Craig they should consider? Why was that thrown in? Because doesn't that kind of count? Helps the defendant's argument here today, doesn't it?
You're talking about the nature of the instruction itself?
Yes, yes. The last sentence, this instruction applies only to the witnesses named and not to the other statements you may have heard regarding Billy Craig in this trial.
I'm sorry, I can't find that. I can't answer your question. I just know that there were You're referring to the last sentence?
The last sentence, yes.
Those other evidence involving Billy Craig and other statements made by Billy Craig, I believe, that weren't incriminating against the defendant. I can't recall exactly how that came out. But clearly the defense agreed to it. There was no objection to it until the very end, and they said that they wanted to object to it. Just
How
consistency.
How could any statements from Billy Craig come in incriminating or otherwise?
Well, they could come in as co-conspirator hearsay, vicarious admissions under KSA 6460.
But that isn't what you presented to the judge. You said 6468, present and available for cross-examination.
Right.
Isn't that the reason that you gave to the judge for allowing the hearsay?
At the time the objection was made, we said he was going to be present to testify.
What were any other grounds or any other subparagraphs of 6460, any other exceptions argued to the judge?
I don't recall. I think at the time we expected Billy Craig was going to testify.
And if that's the sole basis, then it really doesn't matter whether the statements are incriminating or not, because he wasn't present and capable of being cross-examined.
Well, then we're looking at whether or not he was harmed or prejudiced. We're going to go back down to exactly what the issue is here. The issue is, did the court commit error by denying the request for a mistrial? That's what we're looking at, is the prejudice. Have we reached a point in the trial where the defendant couldn't get a fair trial, where there was no way to fix it?
What is our standard review for that question?
It's abuse of discretion. There's actually, when you look at the Gleason case and the Harris case, there's kind of a two-part test. And it always confuses me because the first part actually has two parts. So it's kind of a three-part test. It's, was there a fundamental failure of the proceeding? Is it possible to continue without injustice? And then the second prong is, can the prejudice or prejudicial conduct be cured by jury admonition or other action? Then we look at whether the court abused its discretion. I want to hit on something that was the question about whether or not there's been a plea bargain or some type of plea
Well, yeah, I want
bargain.
to get into that because you represented to the court that Mr. Craig was going to be available for cross-examination each and every time this hearsay objection was made. And what assurance, what knowledge did you have that he was going to testify?
Well,
just saying he's available doesn't mean he's going to testify. You had information from his counsel that now he's not going to testify. That was apparently given to you at some point during the trial. So what basis did you have that he was going to testify?
The judge found in this case, and if you look at volume 8 transcript, page 71, that the state had a good faith basis for believing he was going to testify after she set through the case and listed all the facts. First of all, the defendant in his own criminal case, which is attached as part of the appellate record in this case, filed a motion to enforce the plea agreement in his case. And he filed that before trial, before Mr. Logsdon's trial. What he was trying to say is that at the time he talked to police and he made statements, he was being promised he wouldn't be prosecuted in return for the statements if he cooperated in the prosecution and testified. So he entered into that agreement. He was trying to enforce that agreement in his case across the hall. That's part of it. So we have reason to believe if he wants to enforce his plea agreement, he's going to agree to testify when we call him to the stand. Second of all, we...
Oh, explain that. You have refused the plea agreement. He's trying to get it, and so that means he's going to testify without the plea agreement.
Well, I'm not sure that I can explain it. He was trying to say that we had made...
No. Let me see if I got this straight. You had withdrawn the plea agreement. Or you were not going to go through with it?
He backed out of the plea agreement.
Okay. But he had no plea agreement.
We didn't believe he had an agreement. He believed he had an agreement, and he wanted it enforced. And he had filed a motion in his case across the
And
hall.
so why would he gratuitously testify unless he got the plea agreement he was trying to enforce?
Well, he believed that he would get that plea agreement and would be enforced as a contractual right across the hall by another judge.
We're talking past each other, I think.
So that was the state's impression, was that if he filed this motion to enforce the plea agreement, he intended to carry through the plea agreement, cooperate with the prosecution. So that was one of the things that we had to look at. Another one was the fact that he had, we knew we could grant him testimonial use immunity. We were prepared to do that. In fact, I think the discussion was made at trial we could do that. We had contempt of court. That had worked with 4 witnesses during the case. 2 witnesses had said they wouldn't testify and changed their mind and threatened with contempt. 2 other witnesses were found in contempt of court and later purged themselves and didn't agree to testify. We had plea negotiations that were in effect throughout this case. If you look at volumes 8, pages 26 to 27, and volume, I think 17, pages 162 to 164. You'll see the plea negotiations were in effect. And there was a question that asked about whether or not counsel for Billy Craig was aware he was going to be called a witness. If you'll look, I can find it, it's in my brief. His attorney filed an entry of appearance on behalf of Billy Craig as a witness in this case long before trial. He entered his appearance as counsel for Billy Craig as a witness. That's in the appellate record. He knew that Billy Craig was going to be called as a witness. He filed a motion to enforce a plea agreement he believed he had with detectives that the state had signed off on early in the investigation.
There again, you're confused. Why would Craig's attorney need to enter an appearance in this case just because his client's been subpoenaed unless he wanted to be there, have the judge on notice that he was going to be there to protect Craig's rights?
Well, I think that's why he filed the
Sure, and he's going to protect Craig's Fifth Amendment rights not to incriminate himself. And why isn't that a big red flag that he's not available to testify?
Because it was equally an indication that he was going to accept the plea agreement, or he was going to try to argue that this agreement should be enforced, and proof of it is the fact he was cooperating by testifying. And we were going to give him immunity. At least not immunity, it would be testimonial use immunity.
Did you ever, prior to asserting that he would be available to testify, check with Mr. Craig, check with his counsel that he indeed was prepared to testify?
I know that we talked to him. There was a conversation in the hallway put into the record in which he was told that his client was going to be subpoenaed as a witness in the case. And I know he had filed the motion, again, to enforce a plea agreement across the hall. I can't tell you specifically that his client ever said, my client's going to testify or not. But then again, when you look at the 100 witnesses that were called to trial, we had no guarantees any of them were going to testify when we called them to the stand. We had several that we would ask if we had some reason to believe they wouldn't testify, we would have a hearing outside the presence of the jury. We did that in this case.
Wasn't it a matter of just trial strategy to call him last as opposed to first so you could cure all this?
You know, hindsight, I guess you could look at it and say, maybe we should have called him first, but then we were also involved with plea negotiations, trying to get him, a happy witness would be better than somebody who's on the stand reluctantly. You know,
I
we
was
have,
going to ask a similar question, because I think our case law has been lax in not requiring as a element of the foundation for this hearsay exception that be done. And many other, if not most other jurisdictions require that witness be called to the stand first before you can do lies.
well, you may go into an area that I didn't brief, but I am aware that there is some case law out there that kind of indicates that it's preferred that a witness be called to the stand before statements attributable to that witness are presented. But there's a realization that if a case is so complex and it's so difficult to understand, sometimes going ahead and calling those witnesses in advance to explain it is okay. There's case law that I've seen on that. I think I put it in briefs maybe 25 years ago. The law is, we're calling you had a good faith basis. That was found by the judge.
But when you called him, you knew that he had not pled in this case, and you knew that his testimony would, by necessity, incriminate Billy Craig. Did you not?
No, because we were going to give him immunity. We were going to give him
That was after the fact.
That was when we called him. When we called him, we had to grant the testimonial use of immunity.
But not when you represented to the court that he had credible cross-examination.
We represented that we were calling him as a witness. He would be called as a witness.
Counsel, I think at one point, maybe 10 minutes ago, you basically said, so what? That is, assuming all this to be fair, where does that leave us on this case?
Well, we think the admonition in and of itself to the jury, especially when you look at the facts of the Sappington case, on this one witness, cured the defect. And again, as I started off, there was more than just the testimony of Billy Craig. There was 100 witnesses, there were 200 exhibits. There was-
Mr. Sherman, can I have you be a little more specific about that? I want to just assume with me for a moment. Assume we have a bunch of error. Assume that the admonition was incomplete. And just assume for the moment that we're not going to call that invited error by the defense. Can you be a little more specific than to say we had 100 witnesses and 200 exhibits? Why is this harmless?
I can't.
Okay. You're leading that to that.
We had 9 witnesses who said Logsdon made incriminating statements to them. We had incriminating text messages. We had a Colt .38 caliber revolver that was found in a residence where he was arrested in Nebraska, tested by the Kansas Bureau of Investigation, and it could not be ruled out as the murder weapon. It couldn't be identified as the murder weapon, but it couldn't be ruled out. We had recorded jail phone conversations in which he made statements. We had inconsistent statements he made to detectives. At one point, he said, I can't tell you everything because I would incriminate myself if I did. He made those kind of statements. We had, again, the recreation of the murder in the Fort County Jail. And I documented in the briefing the facts. In fact, law enforcement tried very hard to keep the facts very quiet so that nobody would know about it. There was some question about whether or not the defendant could have had access to those facts. My recollection of the facts at trial and in my brief are that he didn't have recollection of those. And he recreated the homicide to the point of kneeling down on the ground and putting the gun up to his head when that was consistent with the facts that we knew about the crime. Jennifer Hefner was shot 3 times. There were 4 shots. One was a wing shot that went across her side. One was a through-and-through shot from her back to her chest. And the third was a shot directly in the back of her head. And he's recreating this. And we have other inmates in the cell there in Fort County saying, this is what he's telling us. He's telling us he did this. And then as we're asking him where he was when he told you, he said, out in the day room. And so they pulled the day room video on those days, and they see him doing just as they described. We have other evidence other than the statements of Billy Craig. With regard to, I want to hit on this just as quick as I can. I know I'm running out of time.
You're out of time. I'll give you 60 seconds.
Give me 60 seconds. We talked about the witnesses that were left off of the admonition. and I can't remember which ones they were. I think it was Robert Hill. Robert Hill was talking, in fact, to the defendant. Well, again, I'm just going to say it was co-conspirator hearsay on Robert Hill. It was co-conspirator hearsay on Kayla Rodriguez. And on Kylie Hartman, we showed that that was the defense who entered the statements that are being objected to. It wasn't the state that introduced those. So we're not sure, really, that other than those witnesses, there was anybody else that should have been included on the admonition.
How does the co-conspirator exception apply to counsel's point that the conspiracy had ended before the statements were made?
Well, because the statements were being made at the time of the conspiracy, because the murder hadn't been committed at the time those statements were made.
Not some of them. For example, Carruthers. That was made
No,
after.
Carruthers. I'm not claiming that's co-conspirator. Carruthers was a mistake. We acknowledge that Carruthers was the one mistake in this case that came out, and that's because the detective said he told them that the defendant that Billy Craig said the defendant had shot Jennifer Cutler. On the stand, that isn't what Carruthers testified. On the stand, Carruthers testified Craig told him he didn't know anything about the murder. So it was an inconsistent statement. In person, Carruthers tells the jury, Craig didn't tell me that. It's the detective who says that. We acknowledge that is the one error in over 100 witnesses in over 3 weeks of trial. That's a pretty good trial. I mean, it's one error, but we think the admonition cured that. And that's the state's position on that.
Any further questions? Thank you, counsel. Reserve 3 minutes for vote.
Thank you. May it please the court, I did find that letter from Mr. Stanton. It was actually to another defense counsel for Billy Craig, and it was dated September 16, 2011, several months before the trial. The last page says, the unfortunate fact of the matter is your client has now indicated to law enforcement that he will no longer cooperate, and he is not willing to testify in this case. Additionally, your client has indicated to law enforcement that the information he previously gave, which we believe to be true and accurate, was not accurate, and he has indicated he did not tell officers the truth in providing that information. Because of your client's refusal to follow through with our agreed-upon disposition, your client now stands in the position where he may be charged with a crime of homicide involving Jennifer Heppel, and any agreement in reference to 11 CR 447 is null and void. This was sent by the prosecution to Billy Craig's attorneys prior to the trial.
Is the record sign on that?
I don't have that with me. I believe I did include it in the record, but I don't have that with me.
What, counsel for the state was pressed pretty hard about Mr. Craig and his knowledge about when he testified. What about you pressing that at trial when these objections were made and saying, well, we don't have any information he's going to testify? That's absent from any kind of, at least any kind of reading I've done of the record, that you didn't press it. You accepted that proposition was accepted.
Well, I don't believe he had any of his knowledge prior to the trial and prior to that hearsay statement being admitted under the exception that he was going to testify. At the sentencing hearing...
Just let me clarify. You're saying defense was unaware that the prosecution knew that Billy Craig, prior to this trial, was saying that he had given incorrect information about the trial previously.
That he was going to testify. I don't believe defense counsel knew about this letter regarding Billy Craig.
You say in the letter that Mr. Stanton said that Billy Craig was alleging his prior statements were inaccurate and not true.
And I believe that was the substance of the cross-examination of Mr. Craig. If he'd been on the stand, he certainly could have gotten to that.
But if you didn't make any allegation or you didn't raise any issue of Brady issue about failure to turn over exculpatory evidence, that's not an issue here.
Yeah, I don't believe that's an issue because I don't believe that they necessarily withheld it. I guess maybe this letter was information that maybe I should have given him, but Defense Counsel for Mr. Loxton. But I believe the state did know, and they did not talk to Mr. Loxton's attorneys before the trial, to tell them that, or I'm sorry, Mr. Craig's attorneys, to tell them that they intended to file him. The testimony at the sentencing on the motion for mistrial, Mr. Craig's attorneys testified that they did not have any communication from the state until October 23rd that they intended to call Mr. Craig. In addition, he also ran into the state on the steps of the courthouse, and Mr. Bell testified that he told Mr. Stanton that Mr. Craig was not going to testify. So the state knew that, at least partway through this trial, and they continued to assert that he was going to testify.
Counsel, I see you're out of time. Would you like 30 seconds to wrap up? Do you have any points?
Well, I do believe I've made points. I would submit to the court that there was reversible error here, and we can ask the court to remand it for a new trial.
Very well, thank you. Thank you both for your arguments this evening. The court will take this matter under advisement. That concludes this evening's special docket. The court is now adjourned. If you would please keep your seats while the court go to the right so we can safely meet you out in the commons area for reception.
All rise. You may be seated.